everyone to this special seminar on deserters, draft evaders and refugee law. My name's Sara and I'm based here at the Refugee Law Initiative at the School of Advanced Study, and it's my very great pleasure to be welcoming you all to this event and to have the opportunity to introduce our distinguished lineup of speakers on this topic. Thanks to everyone who's joining here today. We also have a number of people joining online as well. The format today is following some short introductions. There will be presentations from each of our speakers, and then we will open up for broader question and discussion as well. But first of all, please let me introduce our speakers. So we will start on my far left, I would say. We have Dr. Sara Arapiles, and she is a postdoctoral fellow at the Faculty of Law at Lund University in Sweden, where she's working on a new interdisciplinary project, Refugee Finance, Histories, Framework and Practices. She recently completed her PhD at the University of Nottingham, focused on slavery in refugee status determination procedures in Europe, focusing particularly on the study of approaches to Eritrean protection claims. Seated next to Sara, we have Lorne Waldman, who is a practicing barrister at Waldman and Associates in Canada and has argued many of the leading cases in Canadian immigration and refugee law. Amongst Lorne's publications are Immigration Law and Practice, the definition of the Convention refugee, Canadian immigration and refugee practice, and Inadmissible to Canada, the legal barriers to Canadian immigration. Lorne is currently a senior visiting fellow here at the Refugee Law Initiative, and he was previously appointed as an adjunct professor of law at the University of Ottawa as well. We also are privileged to have with us Fripp, who is a barrister at 36 Public and Human Rights. Eric has appeared in many leading cases concerning refugees, immigration, nationality and human rights. He is moreover a senior visiting fellow at the Refugee Law Initiative, and his authorship and contributions to academia include his book Nationality and Statelessness in the International Law of Refugee Status and The Law and Practice of Expulsion and Exclusion from the United Kingdom, for which he is general editor. And last but not least, we have with us Professor Özgür Çinar, who is a Professor of Law and Deputy Head of the School at the University of Greenwich. He completed his PhD at the University of Essex in 2012 on the subject of conscientious objection to military service and the case of Turkey. Previously, he's worked at various different institutions, including the University of Essex, BPP University and the University of Oxford, and since 2008 he has also worked as an expert advisor to the Council of Europe. So we have a really fantastic lineup of speakers with us today. Thank you all so much for joining us. I should add that this is a special seminar which has been sponsored by 36 Public and Human Rights and co-organised alongside the Refugee Law Initiative, so thank you very much as well to those chambers. I will now hand over to the main deal of today, right, which is our great speakers, and if it's all right, I would hand over to you, Sara, for your presentation.
Thank you. Well, first of all, thank you so much for the invitation to come today to talk at this very important event. So I'm going to be talking about a topic that took me 5 years of research, so summarizing it in 10 minutes is going to be challenging, but I hope that I will manage, and I will try my best to do that. So the main questions that I'm going to try to address are the following. When does military service become a form of human exploitation, particularly forced labor or slavery? And whether and how a person that is fleeing a military service that amounts to either forced labor or slavery would meet the definitional criteria of a refugee in the 1951 Refugee Convention. And I'm going to address these questions by using as Eritrea's military national service as a case study, which actually was the focus of my thesis. And I think that given the widespread tendency to label all forms of human exploitation as modern slavery, my presentation will bring some conceptual clarity, or at least I hope so, about what forced labor and slavery are in the strictest sense of their legal meaning. So a couple of years ago, several NGOs and scholars celebrated a ruling of the Dutch Administrative Jurisdiction Division, which is the highest administrative court in the Netherlands, because it ruled that Eritreans conscripted into the country's military national service were at risk of inhuman treatment contrary to Article 3 of the European Convention on Human Rights, due to the conditions under which it takes place. I was probably the only one who didn't celebrate this ruling, and the reason is that the Dutch court also ruled that performing military national service in the country could not be considered to be forced labor under Article 4.2 of the ACHR, because in its view it falls under Article 4.3 of the ACHR, which excludes from the scope of forced labor a service of a military character. And actually didn't go any further in the assessment, despite having cited approvingly the MST and others, which is the country direct case on Eritrea, which still applies today in the UK, and which was rendered by the UK Upper Tribunal in October 2016. And this ruling made positive findings on slavery in the military national service after a lengthy assessment of the conditions in the country. And actually, MST and others is the first judgment to assess whether the Eritrea's military national service gives rise to a real risk of exposure to treatment contrary to Article 4 of the ACHR, which includes not only the prohibition of forced labor, but also the prohibition of slavery and servitude. So the Upper Tribunal, the UK Upper Tribunal, made plain that the work exacted from Eritrean conscripts is not considered to be military in character, because it's also used for ordinary public wars and in the private sectors, and also extends indefinitely. And as widely documented, and if you don't know, the work that is demanded from Eritrean conscripts include also work, forced labor in private constructions, sites, farms, military operations, infrastructure projects, for the government development programs, in foreign companies that are operating in Eritrea, in the administration, school, judiciary, everywhere in the country. And actually, Eritrean domestic laws establish that the work that is demanded from Eritrean conscripts is used also for the purposes of, and among other things, national reconstruction and the economic development of the country. And is therefore, according to the UK Upper Tribunal, ILO, the International Labour Organization, and many other bodies, not for purely military purposes. And the word purely is used in the 1930 Forced Labor Convention that was adopted by the ILO, and similar to the European Convention of Human Rights, excludes from forced labor any work or service of a purely military character. And actually, MST and others said that this is strengthened by the 1957 Abolition of Forced Labor Convention, which prohibits the use of forced labor, and I quote, for the purposes of economic development. So a service that goes beyond military service, because it's not purely military, because it entails tasks that are beyond what military tasks should include, falls outside the permitted exceptions to forced labor, both under international human rights law and the ILO forced labor conventions. So MST and others kind of assimilated the right not to be subjected to forced labor under Article 4.2 of the ACHR to the right not to be subjected to ill treatment under Article 3 of the ACHR, finding that there was a factual overlap between these two rights. And it concluded that the national military service per se amounts to a flagrant breach of the right not to be protected against forced labor and to persecution in its own right. And actually, UNHCR handbook admits that forced labor and slavery constituting serious human rights violations would be considered persecution under international refugee law. So the question now is persecution on what ground of the Refugee Convention. So for MST and others, it's persecution on the ground of imputed political opinion, because among other reasons, the Eritrean government regards the military national service as a patriotic duty. And although MST and others did not pronounce specifically on the ground of membership of a particular social group, it also specified the various groups that on return face a real risk of persecution, which in essence include any individual of or approaching draft 8 who will be perceived on return as draft evaders or deserters. So MST and others did a great job up to this point, but not with regard to its assessment of slavery, to which I will return shortly, but I'm going to refer now to a few other judgments from other countries. So the Federal Administrative Court of Switzerland, which is the highest court in the asylum procedure in the country, replicated MST and others' interpretation of forced labor, but it did not consider the military national service as capable of amounting to a flagrant breach of Article 4.2 because it's a derogable right. And actually, after this ruling, most Eritreans in Switzerland, this ruling is dated 2018, are being denied not only refugee status, but also international protection altogether in the country. A few years after, the Administrative Court of Gießen, and a year after, the Higher Administrative Court of Hamburg in Germany, contrary to MST and others and the Federal Administrative Court in Switzerland, consider the military national service in Eritrea to benefit from the exclusion criteria in Article 4.2 of the HEHR, the one on military service, despite having argued that actually it not only entails military tasks, but also works in the public and private sectors, and is used for strengthening the economic development of the country. They further argued that even if it were to be considered forced labor, it does not meet the threshold of a flagrant breach of Article 4.2, citing approvingly the judgment of the Swiss Federal Administrative Court. So let me now return to slavery, which is actually a non-derogable right, and I use cover norms, and I guess we all know that violations of non-derogable rights reach the threshold of persecution. So MST and others did also assess slavery in Eritrea, but made negative findings. And actually the other courts that I referred to replicated at face value MST and others' interpretation of slavery, despite its flaws. And actually MST and others set unreasonable requirements to satisfy Article 4.1, which includes the prohibition of slavery and servitude, by understanding that actually two factual elements need to be met to satisfy Article 4.1. Legal ownership over people, and a permanent or lifelong condition. And actually none of these elements are part of the definition of slavery, which is found in the 1926 Slavery Convention, and which defines slavery as the exercise of any or all of the powers attaching to right of ownership over a person. It speaks of powers attaching to the right of ownership as opposed to legal ownership. And actually, if we look at the version of the Spanish version of the French version of the 1926 Slavery Convention, powers attaching to reads as the attributes. So the attributes, the characteristics of the right of ownership, as opposed to legal ownership. And actually how courts, and this was also what was in the mind of the drafters of the 1926 Convention, and actually in the 1926 Convention, chattel slavery had been, or transatlantic slave trade had been already abolished in many parts of the world. They were not concerned about the legal ownership of people. And actually, according to international criminal law tribunals and courts and regional human rights courts, the exercise of powers attaching to right of ownership translates into the exercise of a substantial degree of control over a victim in a way that restricts or deprives a person of their individual liberty or autonomy. And through that level of exercise of control over a person, one person can use, exploit, economically exploit, dispose, transfer, enjoy, lend, etc. another person at their own whim, and for whatever purpose. It can be, as in the context of Eritrea, for the purposes of exacting forced labor from people. Actually, forced labor and slavery are not mutually exclusive. They can happen at the same time, and actually forced labor, among other factors, is a factor indicative of slavery. But forced labor is not sine qua non of slavery. someone may be subjected to slavery for reasons other than exacting from that person forced labor. For instance, for sexual gratification, for the purposes of re-education, or to achieve military and/or political goals. So the course that I referred to, and I'm just going to conclude, overlooked relevant factors that indicate that the military national service in Eritrea amounts to slavery as per the definition of slavery in international law. So, to sum up, military service can constitute forced labor and/or slavery. And I think it is important to use the definition of slavery and the definition of forced labor properly, and not to misuse international law to unduly deny refugee status to people who truly deserve it. Thank you.
Well, thank you so much, Sara, for kicking us off with such an engaging discussion. And I found it really fascinating the way you went all the way back to that 1926 Slavery Convention to draw out what is, I think, a much more relevant and applicable definition of slavery that could be considered for these cases. So thank you so much. We'll move directly on now to our second speaker today. We'll have the opportunity for questions and discussions at the end. So our second speaker, Professor Özgür, Çinar, I hand over to you.
Great pronunciation.
Thank you. I think it's my crowning achievement of the year.
I know, it's very challenging, isn't it? To pronounce my name, I know.
Let me just pull up your presentation.
Thank you very much. Can I just, yes, I mean, two things. 10 minutes is going to be really challenging as a lawyer, I have to say. And secondly, I'm a quite hyperactive person. I'm sorry, I can't sit down and, I like to prefer to stand up and talk, okay? So, today I'm going to talk about the conscientious objectors. I know the subject is about the deserters, draft evaders, and etc. And when you're a deserter or draft evader, you don't have to be an objector, but all the objectors, they are deserters and draft evaders, okay? So, and this is the one I have to press?
I think you can go this arrow.
Okay, yeah.
So it's, if you
Is it? Okay, it is working. Perfect.
Yeah.
All right, okay. So, some background information about the conscientious objection to military service. And the conscientious objection to military service is a way of taking a stand against a war or compulsory military service for the sake of principles based on religious, conscience, ethical, moral, political, philosophical, humanitarian, or similar convictions. All these reasons they have been accepted in international human rights law. Okay, so this is the first, I think, is the important point you need to keep in mind, because when we, in a minute we will also compare the specific grounds stated in, in Refugee Convention. We will compare. Okay, so. But there are the principles, there are the reasons being accepted in international human rights law if you wanna claim or become a conscientious objector. And then the question is there any specific document in international human rights law recognizing right to CEO explicitly? There are only two documents we have. One of them is Article 10/2 of Charter of Fundamental Rights. Another one is Ibero-American Convention on Young People's Rights. Okay, so if you look at 10/2, it says right to CEO is recognized in accordance with the national laws governing the exercise of these rights. Okay, it doesn't really say much and is very brief sentence. Okay, it doesn't even say what specific grounds you can make your CEO application. It doesn't say anything. But then what we have to do, we have to look at Human Rights Committee views or the European Court of Human Rights cases. Okay, so, and when you look at both, I'm happy to say it right now because there was a problem. The European Court of Human Rights, it was not in line with the United Nations Human Rights Committee views for a long time until 7th of July 2012, 11 Bayatyan case, and finally now the European Court of Human Rights also recognized right to conscientious objection to military service as a legitimate expression of freedom of thought, conscience, and religion. Okay, so, and this is the one last I would say 12 years after Bayatyan, there are many, many cases now from Turkey specifically, from Azerbaijan, okay, and there are many cases now the court recognize the right to sue as a legitimate expression. So, there is still some approach difference, let me say, different opinions, the way how the United Nations Human Rights Committee approaching the right to conscientious objection. The United Nations Human Rights Committee evaluated the right to CEO in the context of forum internal. But the European Court of Human Rights, they accept the conscientious objection to military service in the context of forum external. There is a huge difference. Forum internal, it means states cannot interfere with a person's inner being. Okay, so basically, and the forum internal is saying your rights is absolute. Okay, so non-derogable rights. Okay, so but forum external, it says if there is a legitimate aim in the proportionate way, and the states, they can interfere with a person's inner being. Okay, so this is the difference what we have at the moment between United Nations Human Rights Committee and the European Court of Human Rights. So overall, I have to say United Nations Human Rights Committee is more liberal, more open-minded, and I think the way how they interpreted the international law, definitely in the light of Article 31 of the Vienna Convention, unfortunately, the Court of Human Rights still not in the level what we expect. Okay, so, but then, if we just come to international refugee law, there are the main documents we need to look at to understand what the objectives, what kind of rights they have got under the umbrella of international refugee law. And Article 40 of the Universal Declaration of Human Rights is the starting point. It says everyone has the right to seek and to enjoy in another country asylum from persecution. Alright, again, doesn't say anything much, but you know, the Universal Declaration of Human Rights position in international law is not legally binding document, but is the fundamental document we always take into account. And then, of course, the Refugee Convention, Article 1A2, is saying well-funded fear of being persecuted. It means there must be a persecution, all right, and you have to have a well-funded fear of being persecuted, and there are 5 specific reasons stated in Article 1A2, okay? So, now, the first question I always ask, why was this definition kept short? Of course, the reason is, and the creators, they want to give much power to states to basically margin of appreciation of the states issue. Okay, so they want to give more power to states to interpret Article 1A2. That's why they keep it very short. And the second question is, the above mentioned stated reasons are in line with the accepted grounds of CEO in international human rights law. You know, do you remember the first slides? And I put all these accepted reasons in international human rights. And when you compare, there are only 5 reasons stated clearly in Article 1A, right? But here, as you can see, is quite broader concept we have. And then any mention of right to conscientious objection in the convention? Not really, no. And there is only one article we need to look at, Article 1F, okay, so it says the provisions of this convention shall not apply to any person with respect to whom there are serious reasons for considering that A, he has committed a crime against peace, a war crime or crime against humanity. So anyone saying, look, what you are doing, let's say in Gaza, all right, I don't want to involve in this, all right, and directly or indirectly, is it possible to accept this person as an objector and give the asylum seeker position, you know, status? This is a question we have to ask, right? And we will come to this point, but, and is it the direct, indirect involvement? Yes. Some national courts is, I have to say, is more liberal. Let's say, for example, there was a case in Italy, Court of Cassation of the Italian state in March 2022, and they says any involvement, even in the indirect involvement, if you don't want to involve in any activities against peace, war crime, and or humanity, and I still accept you and give you the asylum seeker status. Okay, so, but there are other countries that are not really liberal or positive about that. Okay, so, and then there is another document we need to look at, UNHCR guidelines. It says persecution and the grounds, and especially the grounds, if we have to look at, it says religion, okay? But the question is, okay, how are we going to interpret the concept of religion? The religion is just, we need to think in a spiritual way, or is in a broader sense, including thought, conscience? And the guidance says, yes, think broadly, all right? Not only this in a spiritual way, also includes thought, conscience, such as moral, ethical, humanitarian, and other views of this nature. And then the guidelines, page 11, says political views in themselves which highlight an individual's disagreement with the state's policies. But unfortunately, it's not just enough to say, oh, I disagree with my government's involvement in, let's say, in Iraq, in Gaza, or another. No, it's not enough, okay? And you are going to explain about Kroto case, I guess, Sepet Bülbül, all these cases, right? You will talk about it. So, and then another point is the conscientious objectors are particular social group due to their shared belief as a result of their identity. Another reason specifically stated in the guidelines. Okay, so I know I'm running out of time, yes. And then the last one is handbook, okay? And the handbook, I mean, chapter 5, this is the one I recommend you to have a look. And the paragraph starts from 168 up to 174 and talks about the specific circumstances, saying if you're a religious objector or political views you have got and what you need to really show. But if you look at these paragraphs, the main point is here, if you, as long as you show you are genuine on your beliefs, religious beliefs or non-religious beliefs, and then, yes, there is a possibility to your application, your asylum seeker application is going to be granted, okay? But the problem with this, okay, how are you going to prove you are genuine or not? All right, so, and this is the question what we have. And then the EU Directive, Article 9.2, again, doesn't really talk about all these specific grounds, what we have in guidelines, only says the crimes or acts falling under the exclusion clauses, okay? It's very narrow, that's why I put the question, which one? The Human Rights Commission of Refugees or EU's directive has a wider approach, and I have to say, yes, United Nations Human Rights Commission of Refugees guideline is a more broader approach into recognizing the conscientious objectors as a asylum seeker, okay? So, and then the conclusion is, now what we are going to do, okay? There's a person who is being forced to compulsory military service among the persecution. Unfortunately, most of the countries in the national level, they don't interpret it that way, okay? Even the guidelines doesn't really help us, okay? And but in my opinion, as a lawyer and as an academic, and I think they're on the wrong footpath. And what they always do, they always take into account political, diplomatic relations, and also economical reasons. But we are, at the end of the day, we are talking about the fundamental human rights, okay? So if rightly conscientious objection to military service has been accepted as a forum internal aspects of freedom of thought, conscience, religion, it means, it's also freedom of thought, conscience, and religion stated as a non-derogable rights in Article 4 of ICCPR. It means fundamental rights. No states can really interfere with this right. Why not? I mean, why why you are going to take into account political, diplomatic relations and economic reasons. You need to focus on the fundamental freedoms and rights, and you have to give ground to the objectors, okay, when they are seeking the asylum seeker status, okay. So, and also another advice we have, of course, they have to, because we have Article 31 of the Vienna Convention. It states, and they have to interpret the statutes in the light of the current developments. And so the current development saying CO is a right, okay? Legitimate expression of freedom of thought, conscience, and religion. And therefore, and it's one of the basic fundamental rights, you can violate this freedom, and you need to give the asylum seeker status to the people, to objectors. Thank you very much.
For a really great talk, which I think really did a really fantastic job of unpacking conscientious objection and the way that it can slot in or not in the various different aspects of the refugee definition. I love the argument that you made at the end about conscientious objection being recognised as a human right then, and what the implications that can have for recognising denial of conscientious objection as a form of persecution. Thank you so much. We will move on now to our third speaker, Eric Fripp, and just give me a moment and we will set up your PowerPoint, Eric. There we go. Okay. And that should be displayed nicely, and I'm hoping you might be able to click.
So, can we switch? Otherwise my presentation will be projected onto my face.
Yeah,
So there we are. Although, of course, there is something to be said for having your presentation projected onto your face, because it becomes unmissable. So
There you go, so you can just click through the arrows there.
Clicking along.
And it's
The arrows aren't working.
sorry, let me just put it onto the presenter.
and the pen.
Alright, so it is changing through behind you. It just doesn't show you the screen. It shows
Okay.
the display. So you're
Lovely. Yeah. Well.
you can look at it on the screen.
Yeah, well, Sarah, thank you very much. Thanks to my fellow panelists and audience. I'm a working barrister, you know, and I study this stuff a bit on the side. One thing that differentiates the ability to do some academic study to being a working barrister is you are dependent who comes in the door and with what account. And so I don't want to give a false impression that I see a lot of military service cases, and I don't think very many people practicing in the UK do. Trying to estimate it earlier, I thought, well, in the last 20 years, I've seen perhaps 12 military service cases, or fewer, Georgian, Eritrean, but a very small number. Another thing is that this area of law, I think, is quite unusual in refugee law as interpreted in England and Wales, or the UK, in which England and Wales is effectively in this area the dominant jurisdiction. It's unusual because, unlike, say, Canada, where Lorne practices and where appeal upwards to more senior levels is very difficult, and so many cases that stand deciding quite important points of law go back and haven't been reviewed on appeal since the 90s. And in the UK, there is a relatively friendly appeal route if you have a point. And I'm being looked at in a way that has meaning to me in this context. But where issues need to be refined, they very often are in this jurisdiction. But that hasn't happened very much with military service. You know, the leading decision, the decision of the House of Lords in Seppet and Bobo, goes back a generation in lawyer terms. and has never been substantively reconsidered. I want to deal with that in the course of the presentation, but moving here. So, the starting point, Article 1A2, and you'll see why, albeit you'll know this very well, I'm starting from Article 1A2. And the core of it, relevant to my subject, owing to well-founded fear of being persecuted for a convention-relevant reason, for a convention reason. Critical elements in the sort of cases I'm going to be dealing with, well-founded fear. That fear is of persecution, and it's for a convention reason. In principle, there's only one true interpretation of the convention, and the task of any interpreter is to try to deduce and narrow towards, to, ideally, that interpretation. There's a need for consistency, which informs the interpretive task, and that there are many sources. I've taken a succinct account of that from Mark Symes and Peter Joro's book. So, I'm sorry. Whether persecution arises. Persecution is essentially interpreted through consideration of international human rights law by reason primarily of the preamble to the convention, which refers to fundamental rights and freedoms, and to the UN Charter and to UDHR. And of course, you know, the ICCPR wasn't to become binding law until a decade and a half later. So there's been said to be a manifest need for consistency as to what species of ill treatment, and then the handbook, deserters, persons avoiding military service. I don't want to spend my 10 minutes or the 8 minutes that remain just talking about the handbook. The handbook was drafted by people at a time when there was very little jurisprudence and very little guidance, and that shapes the way it was done. It was drafted by people who clearly knew they couldn't exhaustively enumerate every category of case that might arise, or every weighing of factors that could be relevant in any particular case. So they were concerned with, in essence, a general program of guidance to say what was unlikely to be within the definition, what was more likely to be within the definition, but not defining in a categoric way what is within the definition. An important thing about military service, public international law, as Marty Koskiemi has said, is it's not a suicide club for states. So states are entitled to have in place legal provisions requiring military service, and this is an area this is something which lends difficulty to interpretation, because there are things states legitimately do and are expected to be allowed to do, and there are states where there are matters where they don't have any latitude at all. So, as Lord Justice Laws observed in the Seppet case in the Court of Appeal, torture is always persecution, or always potentially persecution in the right context. So you don't have a question about whether torture is legitimate and within the state's power or not in a given case. You do have that in certain other areas. Prosecution, persecution is the closest parallel to military service. But nationality, where nationality was said in the Tunis claims case to be in principle within the reserved domain, is another one, and one I'm very, very close to. Conscientious objection isn't actually expressly a part of Article 1A2, and Özgür has addressed this. It's a concept of humanitarian substance, but it's one that, as it were, interacts with the refugee definition and is not exhaustive of it. There is a risk of approaching the refugee definition as though it's just about conscientious objection, because that is so much the focus in many contexts. But, you know, self-evidently, if you have a well-founded fear of persecution for a relevant reason, that can arise without conscientious objection. You know, a well-founded fear of being killed or tortured as a deserter by reason of implied disloyalty to the state, that doesn't depend on your state of mind. You may just be a coward, but you are potentially still within the convention in that context. And that's because of, as were the motivation of the state and the agent of persecution, but also and the motivation for that, and the act and the context. Separate and Boble. So Separate and Boble, in the Court of Appeal in 2001, appealed 2 years later to the House of Lords. They were Turkish draft evaders of Kurdish ethnicity, and they essentially had a selective objection to military service, based not on religion, and not on an absolute political claim against the performance of military service, but essentially against the performance of military service at a time when there was no provision for alternative service, and military service risked participation or support of the campaign of the Turkish authorities in the suppression of the Kurdish people of eastern Turkey, in the view of those individuals. The fundamental argument, it's important to remember, because this, I think, has hung over the careers of many of us, has a wider, as it were, weight in that context. And I'll explain that in a moment. But it's a very narrow case. It's really turning on one very tight issue. We would say, well, in a military service case, you have to look at international human rights. You have to look at relevant provisions of international human rights. In Separate and Boble, the appellants were trying, as it were, to jump that shark. And they were trying to do it by saying, we don't have to look for other rights that support our case, because there is a direct right of protection for conscientious objection. That means being required to do military service per se in relevant circumstances is persecutory, because it's in defiance of this overriding right of conscientious objection. That had some sympathy from one member of the Court of Appeal, Lord Justice Waller, but it failed fundamentally, both in the view of the majority in the Court of Appeal and in the House of Lords. In the House of Lords, Lord Bingham, the leading international human rights instruments, literally interpreted, give little assistance in the applicant's argument. And although, for reasons which I've already touched, the reach of an international human rights convention is not forever determined by the intentions of those who originally framed it. So there's scope to move forward towards the realization of a less nascent and more fully formed right of conscientious objection as human rights standards develop. The House of Lords also concluded that there was compelling support for the view that refugee status should be accorded to someone who's refused it on the grounds that it would require him, or her, I'll say, to commit atrocities or gross human rights abuses or participate in a conflict condemned by the international community, or where refusal to serve would engross excessive or disproportionate punishment. Now, by our system of precedent, a case is binding in relation to its facts and the decisive findings of law relating to those facts in it. Here, the decisive finding effectively is there's no international human rights law protection per se of conscientious objection that, as it were, trumps the need to go to other provisions. So it was very narrow, but I suspect practitioners broadly haven't understood that, and haven't understood that to a greater degree, to use a double negative, as time has gone by. And it has, as it were, become a very heavy weight in the sky that provides that you can't run the military service claim unless you're somewhere within the para 8 exceptions, and those are treated not as illustrations of principle, but as exceptions from essentially a prohibition, which is quite disloyal to the content of the judgment, but the judgment has, as it were, aged in its room, whereas other provisions around it have been subject to much more development. Since 2003, very little jurisprudence in the UK, strikingly little. So MST, Sara has addressed MST very learnedly, and I'd like to say I adopt all that she said about that, and her learning is much greater than mine on Article 4. An aspect of the task of both advocates and tribunals. As an advocate, you're instructed to get someone, as it were, over the line. You're not instructed unless you have a lavishly funded and generous-minded client to risk losing by not getting over the line on the most viable basis. And nor are you necessarily, in a normal case, being paid to establish a broader point. And the tribunal may not pragmatically be interested in establishing points of principle if there's another route to it. Article 3 and Article 4, ECHR, there's a substantial overlap, and they both have their equivalents in ICCPR within international law. It was found that military service in Eritrea risk breach of could inflict breaches of Article 3 and of the forced or compulsory labour provision in Article 4. I think that actually a positive point to MST is that there is a broad carve-out in international human rights law for military service or for schemes of a military nature. And the tribunal essentially found that in English legal terms, what the Eritreans were doing was ultra vires. It was beyond what you could defend as a legitimate national defense, national service scheme. PK and OS. PK and OS is a case that seems, as it were, to take one of the points from Sepet and Bulbul Para 8 and to treat that as though it were statute, rather than an example of the proposition. And the broader proposition, I'd suggest, no single discrete right of conscientious objection in IHRL, but there very obviously are broad standards potentially applicable. Torture or inhuman or degrading treatment, Article 7 ICCPR, prohibition of slavery or servitude, and the exceptions are spelled out there. And it's critically important that these aren't seen to be excluded by overexpansive treatment of Sepet and Bulbul. Sepet and Bulbul cases, this section, the Para 8 instances, all of those are explicable by reference to IHRL standards, by reference to the slavery standard, or by reference to Article 3. The issue about participation or participation in atrocities, there is no specific human right not to be forced to be, not to involve yourself in committing human rights or IHL, international humanitarian law, atrocities or breaches against other people. But I think it takes little ingenuity to see that as within the scope of inhuman or degrading treatment and punishment for refusal as inhuman or degrading punishment under Article 3 or Article 7. So these are applications of Article 1A2. They're not exceptions or standouts to Article 1A2. I suggest, and if one adopts a flawed and reductive understanding of the Sepet and Bulbul decisions, that's potentially dangerous, as is straightforward error in other respects, such as simply going and looking for conscientious objection when actually the provision in Article 1A2 is much broader. It remains critically important to apply the whole qualification criteria, not to fetter this artificially, this is important because after a long time, when either states have abandoned military service or they've reduced it so greatly that getting out of it is no longer the challenge it had been prior to 1989. We see large state conflict in Europe, and we see serious conflict in the Middle East. And military service, I'd suggest, is arriving back to take our attention again, and it needs to be dealt with in a way that is open and not blinded. So thank you very much.
Thank you so much, Eric, and I think your closing remarks on the enduring or the increased importance of this area are really, really pertinent for the talk today. Personally, I really enjoyed your reflections as a practitioner, particularly on how the format, the structure of litigation in this field has kind of shaped or not shaped jurisprudence, particularly in the UK. So thank you so much for that talk. We will move on to our last but by no means least speaker. I hand over to Lorne Waldman.
Thank you. So I'm going to pick up where Eric left off. I'm a practitioner and I'm practical. And when I speak about this, I'm going to focus on a few cases and sort of explain why I think they ended up the way they did. And there's a stark difference between some of the decisions and others. Basically, the law in Canada is similar to the law in the UK. There's a case in this late 70s, early 80s called Musial, where the Federal Court of Appeal said there's no right to conscientious objection. It's a law of general application, therefore you can't claim refugee protection if your sole basis is refusal to serve in the military. And that decision has been applied over the years many times, and even recently in decisions of the federal court. So there was a decision in 2001 or 2 where the Federal Court of Appeal, I think it's a case that's called ATES, where they basically reaffirmed there's no right to conscientious objection. It was around the same time as the case that Eric just... No, ATES. It's called ATES in Canada. It was Turkish, yeah. Anyway, so that's the basic principle. There was a case called Zofar Gassani, which was decided in the House of Lords decision, because it was before, where the Federal Court of Appeal was involved with an Iranian refugee claimant who said, if I fight, I'm going to have to fight in a war that's going to violate international human rights law. I'm going to be forced to violate them, and therefore I would be excluded if I do what I'm required to do. And the Federal Court of Appeal recognized that that was an exception, and that being forced to violate international human rights was a basis for a valid refugee claim. There was another case called Lebedev, which was decided around the same time. It was a Russian deserter, and he said, if I go back, I'm going to be subject to inhumane treatment in the prisons. They're going to torture me. And he was granted protection based upon the inhumane treatment that he was going to receive. So basically, you can see the principles are the same in Canada as the UK. But we have this big neighbor to the south, right? The United States. And so there was a bunch of decisions that came out of the deserters from the Iraq War, which I wanted to speak about. And there were 2 decisions. One was Heinzman in 2006, and then there was a case called Vassi, and then the other case called I can't remember pronounce it, Tinneman, where the federal court came to divergent conclusions. And so my voice as a practitioner says, well, why was it that the 2006 case was decided one way and the 2 cases that were decided in 2012 and 13 were decided another? There's 2 explanations for this, and then I'll explain to you what happened. Well, Heinzman was decided in 2006. It was just very fresh after 9/11. It was a hugely publicized case in Canada, very controversial. How could we, recognize Canada, that a deserter from the United States wasn't going to get a fair trial in the United States? And so it was a highly political case at the time. The counsel who presented the case didn't present the compelling evidence that he might have been able to present. So unfortunately, Heinzman was not successful. He basically had enlisted in the US Army, and after he enlisted became a Buddhist pacifist, So he was sent to Afghanistan, and he was allowed to do kitchen duty, but then they were going to send him to Iraq, and when he applied to be a conscientious objector, so he wouldn't have to fight, his application was refused, so he came to Canada and made a refugee claim. So his argument in the court was, before the first level tribunals, the United States has not got approval from the UN to be in Iraq, therefore it's an illegal war. I would be violating the laws of war if I fought in this war. And moreover, there's evidence of human rights violations, and I would have to commit them. So the tribunal dismissed it, saying that the evidence of violations of rule of war was irrelevant. The evidence of human rights violations was not sufficient to satisfy them, that he would personally have to engage in human rights violations. Moreover, he would get if he went back to the United States, he would get a fair trial through the U.S. military system. And the federal court basically disagreed on the first point, said no, the relevance of the fact that it would be a violation of rules of war is there, and the tribunal should have considered this, but really a foot soldier you can't make a claim that I'm going to be, I can make a refugee claim based on violating the rules of war, because it's only the senior officials that would be involved in making those decisions, and he was too low down in the totem pole. In terms of violations of human rights, the evidence wasn't sufficient to satisfy them, and he could get a fair trial in the United States based upon the evidence. So this is 2006. So there were evidentiary issues, and there was also political considerations that made that decision what it was. You come to 2012, 11 and 12, there are now two more deserters, Vassi and Tidman, and they make the similar arguments, but of course the evidence that they present is much more compelling. Tindungan is much more compelling. So Vassi is the first case. It was decided in 2011, so we're now further away. We're into a different administration in the United States, and the political atmosphere has changed, right? Moreover, the people that are present compelling evidence in the forms to establish that he would not get a fair trial in the United States. He would not be able to adduce before the military tribunal evidence that there were human rights violations in the US and raise that as a defense to his desertion. So the first level tribunal dismissed it, but the federal court disagreed and said no, the evidence was compelling, it wasn't properly assessed, and there was evidence both that he wouldn't get a fair trial and that he could be compelled to violate human rights. So the decision was set aside. A year later in Tidman, a similar situation arose, and the court came to a similar conclusion, which was basically that as a result of the compelling evidence of very systematic human rights violations being committed by the US military in Afghanistan, and also the fact that the evidence was such that there was no way he could raise any of these defenses in the US military tribunal, that the first level tribunal had erred in dismissing his case. So since then, there have been a series of other cases that have followed this line of thought. One was a case that might have some contemporary relevance. It was not related to the current events in Gaza, but rather to a previous intifada. And an Israeli soldier claimed that if he were forced to serve, the case is called RS. It's a decision from 2012. And he claimed that if he was forced to serve in the military, he would have to violate international rights by serving in Gaza, and that he couldn't, if he wouldn't be able to object, and if he refused to serve, the punishment would be excessive, and it would violate his conscience. And the federal court accepted that the tribunal had erred in failing to take into account that he was a conscientious objector and that he might have to violate human rights and assessing the evidence. It didn't make a clear finding one way or the other, but they set it back on judicial review. And more recently, I'm just about done, so. In the case called Nazmendanov, this is from this year, so it was a Russian soldier in Ukraine. And the same findings. The tribunal accepted that the applicant had a valid case that the Russians were violating international human rights law, and that if he were forced to serve in Ukraine, in the war against Ukraine, he would be forced to violate. What was interesting is they didn't focus so much on the punishment in these two cases, but rather on the fact that the wars were themselves illegal per se. And I think that's an important point to make out. So the moral of the story is, if you want to make a case on points that are contentious, you need to make sure you get the evidence and put compelling evidence, and you have to make sure that the political moment is right. Anyway, thanks very much.
The conflict seems to have played such a dominant role in Canada. I wonder if similar considerations play out in other jurisdictions as well. Thank you so much to all of our speakers for some really fascinating talks. I know that I've learnt a lot. We have a short amount of time now for questions and discussion, so if you do have a question for any or indeed all of our speakers, please do feel free to raise your hands, and we've probably got space for a short round of questions. Yeah? No? No? Okay, all right. Well, perhaps then I will abuse my position as chair and start us off with a first round. So something that struck me in all of these presentations was that the issue of a convention ground to link to the issue of, for these military service cases really seem to loom large, right? And the convention ground that seems to me to have been most hit on is political opinion, but of course we have other options as well, okay? What do you consider to be the most I'd be particularly interested to hear from our practitioners, the most likely successful route to argue these cases, or should indeed there be alternate routes that could be taken? So that's for our practitioners. And Sara, for you, I'd be particularly interested to hear, do you feel that recognition as slavery have any impact on success or not for an asylum case? Like, what would be the impact of that in practice if indeed that was recognised? So I think there's a round of questions for each of you. I wonder, Eric, would you like to kick us off?
Well, Sarah, thank you. I mean, convention reason, I didn't detain you with the handbook, but if you look at the handbook, probably about 2/3 of the text in the handbook dedicated to military service cases as a special case is about convention reason. When there is convention reason, when there isn't convention reason. Around the same time as the Sepet decision in the House of Lords, there was actually what I think is a very good decision on the law of convention reason and political opinion in the then Immigration Appeal Tribunal, now the Upper Tribunal, effectively, in a case called Emilia Gomez. Convention reason then stopped mattering very much to people, and it stopped because the coming of humanitarian protection under European Union law meant that essentially the sticky bits of refugee law, in particular convention reason, didn't have to bother anyone anymore. If you were clearly facing something pretty bad, but you didn't have a clear convention reason, you'd get home on Article 3. And so people say, well, there aren't many good convention reason cases, and there's a reason for that, because it simply ceased to matter very much to adjudication in the majority of cases. It matters only in, say, a relatively small subcategory of, as it were, opting up cases where people are trying to get refugee status rather than an Article 3 related status. I think there is a difficulty with political opinion, and the difficulty is, well, war is political. I mean, it's political all the time. There's nothing about it that's not political. So where, as it were, do you move from an activity which is political in its grounding to something which is reflective of a political opinion in the sense of convention reason? And I think that's factually quite difficult. case by case, often. The cases that spawned this were cases about Colombians, where people would say, well, and this was before Article 3 became directly effective, so I've been targeted for reporting criminals to the police in Colombia. And then you'd say, well, what's your convention reason? It's that I believe in law, which I demonstrated by reporting the criminals to the police. And so you had a lot of cases that went to and fro, Chiano, Gomez, on that, before the struggle ceased to be material to very many people. So I think there are problems. There are certainly difficulties. It's not easy. Another difficulty I found as a practitioner, I had a Ukraine draftivation case relatively recently. Now, and it's a matter, as it were, of narrative, but also of empathy, because most of us don't come into immigration or asylum judging or advocacy because we feel empathy with torturers, very much the contrary. But in the context of a conflict, where you feel the importance of the conflict, humanly and politically, such as Ukrainian resistance to Russia, it does become rather harder. And other things, I mean, here, this was issue number 3, and so it never had to be reached. Getting evidence. Everyone is, as it were, on Ukraine's side here. The journalists in Ukraine are not spending a lot of time trying to judge what's happening in terms of penalties for failure to report to the National Service Corps. It's quite hard to get good information. It's also quite hard to get information that is going to last long enough to base a decision on, several weeks down the road, because things are changeable. And so there are those difficulties, practically. Sorry, I've talked for longer than you probably intended.
No, it's
And I'm a lawyer.
fascinating. Thank you so much, Eric. And Özgür, in your presentation, you spoke a lot about religion as a ground of, as a convention ground, right? And is that grounded in your argument about conscientious objection being a protected human right? Perhaps you could share a bit more about that.
Yeah, I mean, when I say, of course, the religion, as I explained in my presentation, shouldn't be only thinking in a spiritual way. We should, we have to interpret the belief, especially the word belief, in a very broader sense. But the problem is with the, there is a threshold, high burden, things in the refugee cases, and when you come to the political cases, this threshold always set up at a quite high level. Okay, so even when you look at Article 171 of the handbook, says it's not enough for a person to be in disagreement with his government regarding political justification for a particular military action, where, however, the type of military action with which an individual doesn't wish to be associated is condemned by the international community as contrary to basic rules of human conduct. So I have two problems here, okay, and with this paragraph. And
it's a big
one, yes, I mean, well, who's going to decide something is, is associated, condemned by the international community as contrary to basic rules of human conduct? For example, what's going on in Gaza at the moment? Okay, some countries clearly supports the Israeli violations and saying there is no violation, humanitarian issue here. Some countries says otherwise. So you see my point. And let's say you are an Israeli soldier, you don't want to be involved. Forget about criticizing your government. Saying, look, I don't want to directly or indirectly involve in this military action. Okay, so I'm seeking an asylum seeker position in the UK. I don't think UK authorities, they're going to approve this application. So because they don't want to have a problem with Israeli authorities. The same in the United States. And the cases you mentioned, right, is when you look at 2012, actually is not far away, but what you said is very important. Political, the moment must be the right to making an application, especially in the political cases. The threshold is always quite high, and the way how they set up. But when you come to the religious cases, yes, I mean, when you compare the religious grounds with the political grounds, the threshold is lower than what the political grounds, but the problem with the question challenge is you have to prove you're a genuine religious person. And another question, how are you going to prove you are genuine? And how are you going to provide all this evidence, right? And some of the, for example, from Turkey, the people, some certain people, they are Alevis, Anatolian Alevis, and they are more positivist. And so, is it enough to say I am Alevi? If you look at the Turkish identity card, it doesn't say you are Sunni, Alevi, or etc. Okay, and is it enough to bring in a letter from one of the Alevi organizations saying you are Alevi? It's just what does it mean, genuine? So my point is the international law unfortunately gives lots of space to the states, the member states. They call margin of appreciation, right? But the way how the member states, they interpreted the conventions, the Refugee Convention and other conventions, depending on the political situation or economical reasons or diplomatical relationship with the countries, what they have. Okay, for example, if you go to New Zealand, in my research, and the refugee, the courts in New Zealand, they are more, I would say, flexible, open-minded, liberal in the refugee cases. But if you go to Canada, especially if the political moment is not really right, and they don't want to have any problem with the USA, especially American involvement in Iraq and Afghanistan. So in my opinion, there's a hypocrisy here. Okay, so and the international law must be consistent and shouldn't give too much space to the states and giving the margin of appreciation the things, and also the states, and they have to stop taking into account the political, economical, or diplomatic relations into account. They need to really focus on the humanitarian grounds, human rights grounds. Okay, so this is what I feel.
Oh, fantastic, so much. And I think it leads really nicely on to Lorne's key point, which was about the political characterisation of a conflict and, perhaps focusing not so much on conscientious objection itself, but if it was objection to participating in a war which was seen as illegal or in particular acts within a war. Is that correct characterisation of your argument?
Yeah, I think that the 2 points. One is Canada was not prepared in 2005 to sort of accept that we were going to condemn the U.S. for their actions in Iraq in such a political way. And I mean the tribunal was. The tribunal is supposed to be independent, but it can't ignore the political realities, and the judge obviously felt constrained as well. 6 years later, 7 years later, a different set of facts, more compelling evidence. By this time, there was a lot more evidence about what was going on and the human rights abuses that were being committed by the U.S. So the political moment was different. The new administration didn't own Afghanistan in the same way, so it was easier for Canada to move in that direction. I mean, one of the key issues in terms of how you prove it, that you are either politically, and in the Bassi case, the tribunal rejected his claim, saying that they didn't believe in his political beliefs, and the federal court said, well, how could you make that determination? He testified to it, he gave evidence from other people that those were his convictions, and they set aside the decision finding it unreasonable, then went on to analyze the other aspects of it. So when you're talking about proving your political beliefs or your religion, there's never evidence, right? Other than your word and maybe some friend or some letter from some organization. The jurisprudence in Canada seems to have developed to a point where, unless there's some valid reason for doubting your beliefs, it should be accepted. But of course, we spend several hours preparing our clients, and they claim to be Christians, Chinese claimants who are Christians who are being persecuted. They get grilled by the tribunal on the gospel, and so the clients have to know the basic understanding, although they're not expected to be able to know everything because they're practicing an underground religion in China. But so yeah, there's questioning and there's a probing, but it's not that extensive. But it's always a problem, of course, and I agree with friends on that.
I think some of the key challenges, which I think are common across many asylum claims, not only in this specific area. Sara, I think you have the last word. We'd be very keen to hear your reflections, either on this issue or equally on the slavery point raised.
So I think for various reasons, slavery should be recognized as a slavery when it happens and not be confused or interpreted as a different form of human exploitation, such as forced labor, based on incorrect interpretations. So first of all, the definition of slavery in the 1926 Convention has been replicated in 2 other instruments and is considered to have reached customary international law status. Plus, the prohibition of slavery is a jus cogens non, and therefore it should lead to a uniform approach and interpretation. So asylum courts cannot really invent a new definition or add elements to the definition to restrict its application to contemporary cases. And from a refugee perspective, or the practical consequences that it may have to recognize a situation as a slavery and not only as forced labor. For instance, in the UK, Part 5 of the new Nationality and Border Acts includes that victims of human trafficking and slavery shall be provided with residence permit for the purposes, among other things, of their recovery. And it not includes victims of other forms of human exploitation. So that would be one of that practical consequence. But also, I refer to case law in Switzerland and Germany that perhaps conveniently have replicated amnesty and others' interpretation of slavery not to grant them refugee status. And instead, they have misused also what forced labor is, because forced labor, unlike prohibition of slavery, is derogable. And therefore, they argue that it's not violation serious enough as to reach the threshold of persecution as slavery and non-derogable right would be. Or because forced labor allows for exceptions, including for military service. But I didn't say that in my presentation, but also the German courts that I referred to, the Administrative Court of Gießen and the High Administrative Court of Hamburg, also argued that military national service in Eritrea not only benefits from the exclusion criterion of military service, but also the one of civic obligations. So they consider the military national service to be a civic obligation by comparing military service in Eritrea with compulsory fire service in Germany, which I think differs greatly. One is indefinite and the other one is just for a day you may be called to stop a fire. So I think they are just playing with international law for their own political reasons or own benefits.
Clearly very significant implications on the level of protection that such people can receive, depending on that characterisation. Brilliant. We're over time, I'm afraid, so I would like to ask everyone to join me one last time thanking all of our fantastic speakers for some really engaging talks today. Thank you so much. It's been a Refugee Law Initiative event. It's not our last event of the year because we have our amazing annual conference coming up from the 3rd to the 5th of June here in Senate House. So if you are in and around London and are interested in all things refugee law or indeed refugee studies, please do come along and join us. It's looking like it's going to be a really, really great event. But in the meantime, I will ask you to please join us at the back. I can spot some wine and some soft drinks. You're very welcome to partake of and have the opportunity to ask any individual questions that you'd like to any of our speakers. But thanks very much again for kindly joining us today.
Thank you.